and welcome to this week's Artist on Art. What a fabulous show I've got for you today. I'm so excited and privileged and honored to say hello to Danny Sheehan, constitutional advocate, UCSC. You're doing a class tomorrow.
Yes, starts tomorrow.
Starts tomorrow.
On Thursday, the 26th.
Local hero, folks. We've got Danny Sheehan is an incredible constitutional lawyer who has been on the forefront of the biggest cases that have come up before the Supreme Court, which has given us so many, or actually what you've been fighting for are our rights to a healthy and happy life. Danny Sheehan, welcome to Artist on Art.
Thank you, Nada. I'm happy to be here.
I got to do another little disclaimer. If there's anybody that I've ever had on that was as controversial that needed a disclaimer, it would be you, and I'm privileged and proud to say that. But also, people might be listening and say, hey, this is Artist on Art. What's going on? Well, I also believe that art has a component of activism. And if there's anybody who has been an activist artist, Danny, I have to say it's been you and your team, which includes your lovely better half, Sarah Nelson, who was unfortunately supposed to come on the show today, but because of the amazing work that you both do, she had to make some last-minute movements. She had to go to the airport and this and that. But that's okay, because Danny can talk for an hour, no problem. And she can also tell us just a little bit about Sarah, but we'll talk a little bit that later on in the show. So as an artist activist, Danny, you started fighting what you perceive as attacks upon our Constitution.
Yeah.
Since you weren't even graduated from Harvard Law School yet.
No.
You were beginning your career.
Yes, I helped co-found the Harvard Civil Rights Law Review back in 1968. And myself and Mark Green founded it. And I began to solicit cases from lawyers around the country that had really challenging constitutional and civil liberties issues. And they began to flow into me. And I began by doing an initial case that stopped the Boston Police Department from going around arresting all of the men who were distributing the Black Panther newspaper back in 1968. Anytime that a particular robbery or assault of any kind happened where the perpetrator was described as a young black male, the Boston police would take the opportunity to go around and arrest all of the young black men that were distributing the Panther newspaper and bring them in, put them in lineups, and hope somebody would misidentify them.
So would you call this as a profiling type of
Well, no, it was
sweeping?
actually a retribution, more clearly. It was a retribution against them for their free expression. The Black Panther newspaper was constantly criticizing the Boston Police Department for being brutal and
perhaps rightfully.
No doubt about that. No doubt about that part. And that's what was making it so stinging to the police department. And so the police were extraordinarily angry at the Black Panthers in the newspaper. And so they just rounded them up and they would put them in lineups, as I said, hoping someone would misidentify them. And at the end of the day, when they had to let them go because no one identified them, they would have always mysteriously lost all of their newspapers that they had seized when they arrested them. So I was contacted by a young lawyer by the name of John Flim, who had just started practicing in Boston. He didn't know what to do about this, and so he contacted the Harvard Civil Rights Law Review. I drafted up the federal civil injunction and the declaratory judgment to declare that to be unconstitutional, and we won that case in the federal district court in Boston. And that's how it led into my doing the initial case that established the right of journalists to protect our confidential news sources, because following on that, in 1968, you remember, in April of 1968, Dr. Martin Luther King was assassinated. I started law school in the fall of 1967. We began the Harvard Civil Rights Law Review in 1968. And when Dr. King was assassinated in April of 1968, there were major riots that broke out across the country. And one of those riots was in New Bedford, Massachusetts. And so the mayor of New Bedford, the white mayor, declared a martial law in New Bedford and issued a shoot-on-sight order to the police department to shoot on sight any looters that were involved in the riots. And because of that, the Black Panther Party built roadblocks blocking all the roads leading into the ghettos and set up barricades. And the police then all began to gather around these barricades, laying across their hoods with their sharpshooters. And the Black Panthers were all aligned with their weapons behind the barricades. And there was a standoff that occurred there in New Bedford. And a young NBC television journalist by the name of Pappas, John Pappas, actually asked for a set of interviews with the Panthers, and they wouldn't give them any. And so that went on for several days. Finally, the Panthers, thinking that there was going to be a police raid on their headquarters in New Bedford, with helicopters flying in over the barricades and attacking their headquarters, invited the NBC journalist to come in on the condition that he interview everybody on deep background, and if there was an attack against the headquarters as they had anticipated, that then he was free to report all of the interviews and stuff that he had done. But if there were no attack, that he had to hold them on deep background. He came in, interviewed everybody during the course of the night when people were, cleaning their weapons and taking up positions in the windows, et cetera, during the night. This, remember, is 1968. Things were a little different back then. And so what happened is he did all the interviews during the course of the night, and in the following morning there was no police raid. So he packed up all the footage and he left. The raid occurred the following day, the following morning. And the first thing that happened was that the district attorney set up a grand jury inquiring into the connection between the riots, the cause of the riots, and the Black Panther Party. And the first person they subpoenaed was Pappas. And they ordered him to come in, and he had to bring in all of his footage, and he had to be willing to testify to everything he saw and heard, to identify people that were there. And he refused to do it. And he asked the local attorneys for the local NBC affiliate in New Bedford to protect him, and they said there was no protection, that there were no rights that he had. Once he was subpoenaed, he had to go in and provide everything. He then asked them to contact the national attorneys for NBC. They contacted the big firm in New York, the big Wall Street law firm of Cahill Gordon, Sonnet, Reindel, and Ohl, and asked them to protect them. And they said there was no protection. They had no rights. And so what happened is the Pappas called the Black Panther Party in New Bedford and said, "Look, I don't want to violate the agreement I made with you. I don't want to reveal this, but I need some help." So they said, "Here, let's call John Flynn, the young lawyer over in Boston that just won that big case, and have him help us." They just won the case on behalf of the Black Panther newspaper over in Boston. So they contacted him, and of course he immediately contacted me over at the Harvard Civil Rights Law Review, since we're the ones that wrote all the briefs and did the case. So we, for the very first time, I crafted a case asserting the right of journalists to protect our confidential news sources under the First Amendment. And that case went all the way to the United States Supreme Court while I was still a second-year law student at Harvard Law School.
And you won.
And we won. Well, what happened is that when we got all the way to the United States Supreme Court, 48 of the states passed statutes shielding journalists. And took our briefs and set up the argument that before any journalist could be subpoenaed, the district attorney had to prove that it was an extraordinarily serious case involving not just a normal crime, but life or death. They had to show that they'd exhausted all of their attempts to get the information. They had to prove that there was a virtual certainty that the journalist had the information and that the source could reveal it, et cetera. There was a whole series of steps they had to put in, which was in fact the controlling decision, the concurring opinion in the 6-3 opinion that was issued by the Supreme Court, and that was the controlling concurrence. That was a 5-4. That was a 5-4, and the controlling opinion set up all of those standards. So we effectively established the right of journalists to protect their confidential news sources back then, while I was still at Harvard Law School
in 1968, folks. And you're listening to Artist on Art. I am your host, Nada Miljkovic. I'm speaking with constitutional advocate Danny Sheehan, that local treasure. Danny, that case is so important today.
Yes, it is.
Considering what has happened with WikiLeaks and Assange and Snowden and Private Bradley Manning. But I don't want to talk about that just yet. We're going to talk about that later in the show.
We'll get to that.
I want to give a little bit of a background of you, a little bigger picture, because it's so easy to go into each one of these cases. We have 13 cases we're hopefully going to be able to talk about.
Sure.
And that was just the first one, folks. Danny is, congratulations, you have just published a book.
The first of three.
The first of 3 books. And you will be doing a presentation tonight at Logos here in Santa Cruz. It's the first event of your book tour.
Yes, today is the official publication date. And so we've decided to have the original presentation and book reading and signing here in Santa Cruz at Logos.
And it's called The People's Advocate.
That's right.
And this is the first of 3, as you said, a series of books that are going to go through all of the major cases that you've been involved with.
That's right.
Over the last 40 years.
Yes.
And you will have a second book, well, The People's Advocate, but what's interesting about it is that you're writing the book from your point of view, and so you're going through these cases from your point of view, which is similar to what you did last year when you taught a class in Cowell.
Yes.
Correct?
That's right.
And that was about constitutional law.
Yeah, that was called the 8 Cases That Changed America.
And so you spoke of 8 of the 13 cases.
Yeah, that's
right. During that fabulous class, folks, I had the wonderful pleasure of being able to see several of them. You're about to start another class.
That's right.
Here at UCSC. And this class is called The Alternative Theories of the Assassination of President Kennedy.
That's right.
And it's in Cowell 103.
That's the title, yeah.
This title is Cowell 103, Alternative Theories of the Assassination of President Kennedy. It starts tomorrow. It will be meeting for lecture on Tuesdays and Thursdays from 4 to 6 in Social Studies 2, room 71. And you'll also have a section which happens on Thursdays between 6 and 8.
That's right.
And there's still room in your class for any latecomers.
Because the folks just are just getting back now to find out what courses are available, so that they're all engaged in shopping week here now, and so that we're proposing that they come and shop that class. And if they aren't able to get there tomorrow evening, to come on the following Tuesday, because
from 4 to 6, folks.
There's a limit of 50 students in it, but there's still room for some more to come. So the kids ought to come on. It is, in fact, the first time in the entire history of the United States that a college university has taught a course on the assassination of President Kennedy. There are two other schools that touch upon it. They teach a course on legal reasoning and investigative techniques, and they touch upon the Kennedy assassination as an example. But this is the first course ever that has ever taught a course directly about the assassination, setting forth the 10 major theories of the assassination, including the one that will be the subject of the second book that I'm going to be writing.
Hence the segue, the second book in the series called Rulers of the Realm.
Yes, that's right.
And this will be your in-depth analysis, which you will be presenting.
That's right. Along with Dick Billings, who was one of the investigators and the chief staff writer for the House Select Committee on Assassinations, that he is considered to be one of the major living experts on the assassination and the details. And he and I have been conducting a major investigation that has uncovered extraordinarily important new evidence, including new technology used for identifying photographs and stuff in Dealey Plaza to identify who was there, and what is the key to understanding who actually were involved in choreographing this attack.
So I just want to welcome all you UCSC students that are listening out there, and I want to welcome you back to Santa Cruz. We've been waiting for you to come back. It's been a lovely summer, but now it's fall, and it's time for y'all to be back here. I can't say enough about Danny Sheehan's classes. You are a performer in the fullest sense of the word, and your knowledge is so phenomenal. Your ability to devise a story that helps both inform and intrigue and ask questions. It's going to be such a great class. Again, folks, that's Alternative Theories of the Assassination of President Kennedy. It starts tomorrow. It's a COW 103. It begins at 4 tomorrow, and it will be having lectures Tuesdays and Thursdays, 4 to 6.
Is that in COW 103? That's the title of it?
That's the title, and it's in Social Studies 2,
yes.
Room 71, and then sections will be Thursdays from 6 to 8. No section probably tomorrow.
No section.
And so, Danny, again, you are teaching this class, and you are writing the book, Rulers of the Realm.
Yes. That's going on right now.
Which will be, again, the second in the series of 3 books.
That's right.
Tonight being the publication of the first,
yes.
The People's Advocate. Again, tonight at Logos at 7:30. Logos, this isn't the usual thing for them to do.
No. This is one of the very few times Logos has ever done a major book signing and presentation like this. Scott has been a great support for the Christic Institute down through the years, and so a lot of the folks that have been big Christic Institute supporters, which is the 501c3 public interest law firm that we did a lot of these cases out of, and a lot of the major supporters of the Christic Institute over all the years will be there tonight. The publisher of the book, Counterpoint Press, Charlie Winton, will be there tonight. A lot of folks. It'll be a good time tonight. Will be the book, The People's Advocate, is the one that Charlie wanted me to write first, because he wanted to have a 1 mile wide and 10 feet deep, of all the cases, a major dozen cases or so that we've been dealing with, so that people could get a view, a scope of the entire spread of cases that we've done, and open on to the question of what has this taught you in doing these major dozen cases. What have you come to discover, and what is it needs to really be told to the people about what your conclusions are about what you've found during these 40 years of cases. And that is the subject matter of the second book. The second book is digging down into the rulers of the realm to actually explain what the power source is behind all of this malevolent conduct that we've been experiencing.
The power sources and the agendas that go with those power sources.
That's exactly right.
And so, Danny, tell us then the third book, The Dream Fulfilled.
The third book is the book that's going to explain, in light of the revelations that are made in the second book, and what the group is that's behind all of this stuff going on. What is it that we as citizens can do about it? That we see the things falling upon us. That the National Defense Authorization Act, the Patriot Act. The fact that massive surveillance is going on now of all of our emails and all of our telephone calls. There's a huge war being waged on investigative journalists to stop them from getting access to internal government information, which has proved to be critical all the way from the Pentagon Papers, which after all was a top secret classified report, a big 47 volumes of top secret cable traffic, very, very similar to what Edward Snowden had been revealing, and very similar to what Private Manning had revealed. So we have very direct experience going back 40 years of this problem.
So let's just inform our audience. Take a breath, Danny. You're so great. You're a powerhouse. So in 1970, this is actually the third case that we wanted to talk about.
Mm-hmm.
The Pentagon Papers case that you were involved with the New York Times.
Yes.
This is what laid down the groundwork for the ability for you to get that government publication.
Yes, that's right.
Involving the Pentagon.
That's right.
And so what's happening now in 2013 is a
replay. It's a replay. It's the reactionary, ultra right wing of the Republican Party trying to undo all of the gains that our generation basically was able to make, starting in that kind of halcyon year, 1968, when all of those extraordinary things happened with the assassination of Dr. Martin Luther King in April of 1968, the assassination of President Bobby Kennedy, or the would-be president, Bobby Kennedy, in June, on the very night of the very first Harvard Law School exam that our class, the original class. We're the senior class of the baby boomers. And that whole year, and then the collapse of the Democratic Party that was all going to be electing Bobby Kennedy when he was assassinated, and then the disintegration of the convention in Chicago and the massive riots of the Chicago Police Department assaulting all of the demonstrators in Chicago, the extraordinary election of Richard Nixon, of all people, in the fall of 1968, and the beginning of that massive uprising against the war in Vietnam. In 1968, the massive demonstrations, the marches on Washington, all of that is recounted in the book. Because this book is certainly not a story just about me, and it's not just about those cases. Those cases are a window onto that era, that whole 60s era, the boomers, and showing from a unique perspective, that there was a lot more than just sex, drugs, and rock and roll going on during that period of time, though it was a flourishing of art, as we know. The visual arts, the music, the massive concerts, the folk music, the organizing, all of those, the theater, of what was going on at that time in our generation, which has really been one of the most remarkable periods of the flourishing of the arts in American history. But this is the story of that era, so that the People's Advocate is simply an advocate role that I have in that era of advocating the rights and liberties. For example, one that we haven't touched on yet is the second case that I did at Harvard Law School, which was establishing the right of unmarried couples to have access to contraception. In the state of Massachusetts, it was a crime for anyone to provide contraception advice or materials to an unmarried person.
This is 1968, folks. It's very hard to believe.
Yeah, it was quite extraordinary. It arose out of a case of a man by the name of William Baird. William Baird was the vice president of the EMCO contraceptive foam company, and he had been invited to Boston University in the fall of 1968 to actually deliver a talk to the assembled freshman class during orientation. And that rather than just have the normal conversation they have of all the freshmen being gathered together and the president of the university saying, look at the person to your left and look at the person to your right, they won't be here because they didn't study hard enough or they got carried away and didn't do their homework and they're not going to graduate. What this talk was look to the person on your left and the person on your right. One of them won't be here because of an unwanted pregnancy. Oh. And so that Bill Baird was invited by the president of Boston University to deliver this talk to the freshman class coming in the fall of 1968, and he held up a can of EMCO contraceptive foam, and 4 sheriffs from Middlesex County punched open the back doors of the auditorium and came right straight through the crowd and arrested him right off the stage for publicly displaying a birth control device to unmarried couples and took him down.
It's hard to believe. It's so dramatic. It's almost like they wanted to inspire a huge amount of activism, because was that law really that much used?
What it was is that because Boston University had crossed that line of making such a public display of their defiance of the law, that the law enforcement authorities, Eisenstadt, the Attorney General, viewed that as basically sticking the thumb right in their eye about this statute. And he felt, for electoral purposes, with the more conservative voters in Massachusetts, Catholic voters, which are so dominant in Massachusetts, that he had to do something in order to protect his next election. And so he went in and they arrested Bill Baird. I happened to be doing my clerking at the Goodwin Proctor law firm down on State Street in Boston at that time, just at the end of the summer. And because this is orientation period, right? The young freshmen were coming in early at BU, and I was just finishing my internship at law school in the second year. And so I was at the courthouse. I was at the courthouse, at the Middlesex courthouse, on this mundane task of going in at the motions session and standing up and notifying the judge in the motion session that both the plaintiff and the defendants in the cases in one case that our law firm, Goodwin Proctor, was representing, had both consented to postpone a particular hearing, right? So I was there when Joe Bolero, a local criminal defense attorney, and his associate Chet Paris came through the door into the motion session, and a big ruckus broke out because they needed to have an emergency motion, and they were trying to bring on an emergency motion to get a declaratory judgment of stopping this arrest of this guy. And it turns out that they didn't know what they were doing. They were stumbling all over themselves and didn't quite know what to do procedurally. And it turns out I had just edited a note for the Harvard Civil Rights Law Review on that very issue. And so what I did is I tugged on their coat and said, "Look, stand back, let me do this for you." And we did. We brought on the motion for a special decision by the Supreme Judicial Court. We had to get the question certified as an important constitutional question to bring to the Supreme Court of the state of Massachusetts immediately, which we did. We went to the Supreme Court of Massachusetts. They ruled against us, so we appealed to the United States Supreme Court, and the case went up to the federal district court. They sent it to the federal district court, and I actually got to argue the case, even though I wasn't even out of law school. Very kind of a spectacular case, because what I did is I came back to the office at the Goodwin Proctor firm where I was just summer clerking, and there was a notice for me to have to go in to see Roger Stokey, who was the chief of litigation. And so I went in and I said to him, I said, "Look, I know you saw the picture. There was a picture on the front page of the Boston Globe the following morning, walking out of the courtroom." and so the bottom line is, I said, "Look, I know what you're going to be complaining about, but I don't care. That these are the kind of cases I'm going to do throughout the rest of my life, and I didn't mean to embarrass anybody. I didn't use the firm's name or anything." And he just said, hold it. He said, "Look, you don't know it, but I'm legal counsel for the Massachusetts Planned Parenthood Association, and we've been trying to figure out for 25 years how to get this statute declared unconstitutional. What did you do? How did you do this?" And he asked he would have me argue the case in the federal court, and would specially move me to be able to come in. So I went in front of the federal court, and I remember that when I was there, that they had a 3-judge panel actually on the thing, and so that the curtains all fold back, and here are these 3 judges there, and Roger Stokey stands up and makes the special motion for me as a law student to be able to argue the case, right? And the chief judge says, Danny Sheehan. He says, "What's a good Irish boy like you doing in a case like this?" And so I said, "Well, even the Irish believe in the Constitution of the United States, Your Honor." So that was the first time that I ever appeared in court. Oh. And we won the case establishing the right of unmarried couples to access to birth control. And that case of Eisenstadt versus Baird was cited by the United States Supreme Court as a pivotal case on which they made their decision in Roe versus Wade, which established the right of women to choose in the United States.
Hallelujah. Extraordinary. You're listening to Artist on Art here at KZSC Santa Cruz. Danny Sheehan is here talking to us about his art practice, and that practice being fighting for our constitutional rights. We're going to take a little break, just a little bit, so Dan get little drinks of water there, and sit back and relax, listen to a little Cesaria Evora, and we'll be back shortly to talk more with constitutional advocate Danny Sheehan.